Welcome to this week's 2 Minutes Tech Law Update. According to a post on Twitter, which sure isn't the most reliable source in the world, the British Board of Film Classification, the body responsible for setting age ratings for films in the UK and also likely to be the UK's age verification regulator, has said that online social media platforms like Twitter, Tumblr and Reddit will either have to remove all adult content from their sites or else implement age verification. Now, this is a real surprise. Under Part 3 of the Digital Economy Act, it's really clear that persons who make pornography available online on a commercial basis to users in the UK have to implement age verification. But it's really unclear that this applies to the likes of Twitter. In fact, I'd go as far as to say it clearly doesn't apply. Not only are the intermediary liability shields expressly set out in the legislation, but this debate was had in Parliament with the conclusion that Twitter and the others are ancillary service providers subject to a separate regime which doesn't include mandatory age verification. Now, we don't know whether this is the BBFC's official position or just one individual's opinion, and it will be really interesting to see where this goes. If it is indeed the official position, it appears to establish a general obligation to monitor, which is prohibited by EU law. And on top of that, if the BBFC thinks that Twitter and the others do have to implement age verification, it suggests that they may also be of the view that if they don't, the BBFC can compel ISPs to block access to those sites, which is clearly going to be really unpopular. Second, the Information Commissioner's Office has published some updated guidance on its website around various aspects of the data protection framework. One of these updates jumped out at me in particular, and that was around the legal obligation basis of processing. This is the situation in which a data controller considers that it has to carry out the processing in question to comply with law. And two things come out from the ICO's update. The first is that law should be interpreted broadly, and that it covers not only common law, but also covers things like licence obligations placed on regulated industries. Now, I don't think this is particularly controversial, but it's good to see it in writing. The other part that was interesting is that it's clear from the guidance that a data controller doesn't have to be able to cite a piece of legislation in support of the specific act of processing. That specific processing doesn't have to be mandatory. It's enough, according to the ICO, that the processing is for the purpose of compliance with a legal obligation. The processing must still be necessary for the purpose of the legal obligation, so it doesn't give controllers carte blanche, but the clarification is still very helpful. As always, if you want more information on anything in this week's update, please visit our website decodedlegal.com/tmtlu. That's all for this week. Thanks for watching.